Welcome back, guys, after this break for the last session of the day. Good evening, everyone. Okay, so now last 2 hours of the day remain, and our topic of discussion is the contempt of court. Let's give others 2 minutes, and then we'll begin our discussion on contempt of court. Okay, so as far as contempt of court is concerned, there is no definition of this word in the Constitution. Firstly, this word contempt of court is not defined in the Constitution. And then you will say, sir, what is defined? Nothing is defined. Of course, that's true. Things are hardly defined in the Constitution. Not defined in the Constitution. As I said, every restriction on the Article 19, Clause 1, Subclause A has to be done through a law. So we have a law called Contempt of Court Act 1971. So this is something which is a law, a restriction on our freedom of speech and expression. So what exactly is meant by contempt of court? That will be told to us by this law only. This law describes two types of contempts. One is civil contempt. Civil contempt refers to disobeying a court's order. If you deliberately, knowingly, willfully do not follow a court's order, that is called a civil contempt of court. Number two, if you make a statement which scandalizes, attacks the dignity, lowers the authority, or obstructs the course of justice, if you make any kind of statement which attacks the dignity of the courts, which lowers the authority of the court, which creates any hindrance in ensuring justice, make defamatory remarks against the court, those things are called criminal contempt. So contempt basically is of two kinds: civil, don't follow court order; criminal, make derogatory remarks. Civil and criminal contempt. Let me also clarify one point here. If you are publishing some judicial proceeding and it is fair and it's accurate, then that is not contempt, that is allowed. Fair and accurate publishing of judicial proceedings is not contempt. Secondly, fair criticism of judicial actions is also not is also not contempt. fair criticism of judicial action. These things are not contempt. So please don't feel that we can't criticize judiciary at all. But yes, a lot depends on judges' subjectivity. So, but these things are largely not contempt. And publishing any kind of judgment is a part of your freedom of speech and expression. It was said by Supreme Court just recently in the KG Vaishak case last year only. So it is not that you cannot report or publish judgments. They are a part of your freedom of speech and expression. Now, if you cause contempt, what happens? Punishment, of course. A jail sentence of maximum 2 months or a fine of maximum 2000 or both. This is the punishment for contempt. What can be the reason for it? Of course, one reason is to preserve judicial independence. That's the reason why we have contempt. Preserving judicial independence. We want the judiciary to feel independent, not be pressurized by people's critical remarks, uh, remarks which are not based on facts, completely unobjective remarks on the judiciary. They want to be free to give a judgment, and hence we have given this protection, the cloud of protection to the judiciary. And also to, in general, uphold dignity, a sense of authority, a sense of respect, because courts pronounce verdicts and judgment which should be binding on people. If the court has no power to punish somebody for not following an order, then why would you take the order so seriously, right? Now, who can take an action? If you make a remark against the courts, who can take action? Of course, the court of records, which are Supreme Court and high courts. They can do it on their own. If a judge reads, let's say a judge attends my lecture, why will he attend my lecture? But still, and if I make some derogatory remark against the court, which I never make, I respect the courts. So, of course, the point is that he or she can file a case. Secondly, we can also make file complaints, but permission of attorney general or advocate general is required. With attorney general, advocate general's permission. Okay, that's there. So these are two situations where action can be taken. Sometimes, we don't really understand also the limits of contempt of court. I'll show this very interesting example. So this is Prashant Bhushan. For those who don't know, Prashant Bhushan, a very famous lawyer, and Prashant Bhushan is a son of a very famous lawyer, Shanti Bhushan, who is said to be a part of what was probably a very unique first of case of PIL, the Bombay Back Bay case. Or even Shanti Bhushan was amongst the advocates who won the case against Indira Gandhi in the High Court, which led to her disqualification. Anyway, Prashant Bhushan has, of course, he is a very good lawyer in the sense that he will always take up cause for the poor, etc. But then he also has this problem of making remarks which are not backed by any fact. So a few years back, he said that all judges are corrupt. You can't make such random kind of remarks that all judges are corrupt. What do you mean by that? It should make some sense. This made no sense. Secondly, what happened more recently, was that one of our former Chief Justice, Justice S.A. Bobde, so he was the Chief Justice, and he had gone to, I think, Nagpur to attend some kind of function, and S.A. Bobde, I don't know this, but maybe he loved bikes. So while he was there, he saw a bike, a Harley Davidson bike. You know, Harley Davidson bikes, for a bike lover, it's a very nice bike to say sit on, and that was specially a custom bike. So every year, Harley Davidson's custom vehicle operation department division makes a bike for the year. So that bike was the HD CVO 2020 edition. So maybe he got excited and he said, I want to get a photograph on this bike. And he sat on the bike and got a photograph clicked. Now, that bike turned out to be a bike belonging to some local BJP leader in Nagpur. Now, Prashant Bhushan tweets, look at the CJI sitting on a bike of BJP leader. Arey bhai, what do you mean? That bike by chance belonged to BJP leader. Where is the proof? And then remarks like, look at the CGI not wearing a mask and all. Arey, come on. CGI is surrounded by people with safe distance and all. That's okay. And he's taking a photograph. So these kind of random remarks he made on the CGI did not go down well with CGI. So a contempt case was filed. In fact, since he's a very good lawyer and he takes up causes for the poor people, the judges said that, bhai, please apologize, end the story. But he said, no, I will not apologize. And then the judges had to declare him guilty, but they imposed a punishment of only 1 rupee. That's why this, I hereby sentence you to pay 1 rupee. In fact, Prashant Bhushan refused to pay that fine also. He said, no, I won't pay the fine. It was Rajiv Dhawan who came to his house, paid him 1 rupee, and then that 1 rupee was sent to the court. This is not nice. I mean, this kind of kiddish behavior is not nice. You are a very senior, respectable lawyer. Come on, grow up. And you are there for a better cause of public. So why to also, uselessly catch limelight in all these very silly kind of activities? No, my ego has been hurt. Your remarks were baseless. Anyway, so this is how contempt of court can be used also. Now, what are the problems? Problem number one, the terminology used is completely vague. Look at the statements here. Scandalizing the court. What is scandalizing? Horrifying. What is horrifying? What is attacking dignity? What is lowering the authority? It is very subjective. It can vary from one judge to another. These things can be highly subjective. Things like scandalize, things like lowering the authority, etc. Apart from this, this also seems to be more like a violation of principle of natural justice. What is this PONJ? Principle of natural justice. What does this mean? See, PONJ or the principle of natural justice refers to, we know, the three things. Number one, nema causa in judex sua, meaning no one shall be a judge in their own case. Number two, audi alterum partem, meaning what? Hear both the sides. And number three, giving reasons for the judgment. The first one is nema causa in judex sua, meaning what? No one can be a judge in their own case. Look at this situation here. Who is filing a case? Supreme Court. Who decides? Supreme Court. Who gives judgment? Supreme Court. Who punishes? Supreme Court. You are the judge, jury, executioner, everything in one authority. So it actually violates the principles of natural justice. That is actually a problem. In fact, in 1978 only, Supreme Court had given guidelines to itself and all the other lower courts on what should be the at least the guidelines that they should follow, or what should be the correct use of contempt of court, preventing the misuse or overuse. Some generic guidelines were given in what we know as the Mulgaonkar judgment of 1978. So Supreme Court actually said that economic use of contempt is desirable. It's very, very important to use contempt of court rarely. Economic use meaning rare use. Don't overuse it. Rarely. Second, there should be harmony between free criticism and judicial independence. Try to find that balance. Okay. There should be proper harmony. Yes, judicial independence is appreciated, but be open to fair and free criticism also. And media should be given some kind of free space to criticize within limits, of course. And judges should not be hypersensitive. So basically, we are asking the judges to control their emotions. Don't get angry and on the smallest of things. Control your emotions. That is all as far as contempt of court is concerned. Right? Now, with this, we come to an end of our discussion on the very first provision. Let's solve this question first, and then we'll discuss the next articles and their restrictions. For 45 seconds for the answer. Please mark your answer. Done. So, 33% mark B. C and D, I mean, why C and D? Let's look at the statement. The Constitution of India defines, not defined in the Constitution. So, mentioned very clearly. So, this should have been wrong immediately. 3 is wrong. This goes away. This goes away. Now, apart from it, let's now read. So 1 and 2 have to be correct. There is no alternative only. We don't know 1 and 2, still they have to be correct. So 1 is correct, 2 is correct. 1 is a very difficult statement. Pursuant to the report of H.N. Sanyal Committee, the Contempt of Courts Act 1971 was passed. H.N. Sanyal Committee or any such committee, there are hundreds of committees formed under each law. We can't mug up all these things, but look at the options, how beautifully they are. If you can eliminate 3 because you know that fact, you can get the answer. So 1 and 2 or 1, 2 and 4. Now, in India, the parliament is vested with the powers to make laws on contempt of court. Yes or no? Of course, the parliament has the power to make laws on contempt of court. Okay, so 4 is correct. Just to point this out, look at the hypocrisy of UPSC now. Please pay attention. Answer reached to elimination. Great. Gayu Sarma. Oh, very good answer is right for a new student here today. Great. Look at the hypocrisy of UPSC. If you remember, while we were discussing high courts and Supreme Court, there was a question which said that High courts, just like Supreme Courts, have the power to review their own decisions. Remember, under judiciary. And UPSC answer key had marked that wrong because only Article 137 available for Supreme Court. Because Article 137 is meant for Supreme Court only. Remember that situation? Now, think of this point. I had told at that point of time that Court of Records have the power to review their own decisions. But Supreme Court did not, the UPSC did not accept that answer. But look at what they've done right now. The Constitution of India empowers the Supreme Court and the High Courts to punish for contempt. Really? No. They are court of records, and because they are court of records, that is why they have been empowered to punish. So eventually you are accepting this fact that court of records have the power to punish for contempt. Then you should also accept the fact that court of records have power to revise decisions. So a very weird situation that sometimes you will have a change of stand. In the previous year, they had no idea only. So we don't really know what UPSC also does sometimes. Very weird. So that this proves that you may have some issues in some answers in the examination. That is again, that is why I always say that have a safe gap, score heavily to sail through the examination. Anyway, so this B is correct, 1, 2 and 4. Explain again, please. No, it is not some explanation. It is, you can only remember it if you remember the original question. Otherwise, there is no point. There's nothing to explain here. The Constitution of India empowers the Supreme Court and High Courts to punish for contempt. Why? Court of Records have two special powers. One is the power to punish for contempt. The other is the power to review their own decisions. Go to your slides on judiciary. There's a question after Article 137. Okay, 137. Just next to it is a question, and now you can make a sense of what that question was and this statement being correct. They actually conflict, but still this is there. Third point, what's the problem? Constitution of India defines. I am telling here, it does not define. The third statement is wrong, Shreya. Right? If third statement is wrong, we will eliminate the third statement from the options also, and hence we'll get the answer. Okay. Yes, Janvi, Government of India can, with the permission of AG, take action. Not take action, file a case. They can file a case. How can they take action? Only court can take action. Nikhil, all these committees and cases, which committees and cases? All the committees and cases I have told in the class, that should be marked. These type of committees, not really. Trust me, when you see the question, the options will be in such a fashion that you would not need to know these things. But the committees and commissions I have told you, like the Kalelkar Commission, the second backward class commission, yes, they are important. Moving on now to the next group of rights, or next right, and the restriction 19(1)(b), right to assemble peaceably and without arms. Please, let's understand one thing here. You have a right to assemble peacefully. Peaceably is peacefully. And without arms means not hands. Without arms means weapons. Okay. Secondly, right to assemble does not mean assemble anywhere. You have to understand the limitation. Right to assemble does not mean assemble anywhere. You can't say, I want to assemble in Mukesh Ambani's house. No, sorry, you cannot. So, also, very important, right to assemble and say as a mark of protest is okay. This is what is right to protest. Fully allowed. But you don't have a right to indefinite protest. Right to indefinite protest, or even right to occupy public space indefinitely. This is not allowed. This was said by Supreme Court in the Amit Sahni case 2020. Basically, it was in response of the Shaheen Bagh protests. See, whatever your protest reasons are, we are all up for your protest, even if you feel your protest is genuine or based on some ground, whatever. Because, see, I'll always tell you this very important point that if you don't stand up for the protest of others, then it may come to a situation where you have to protest and nobody stands up for you, right? So please don't be like these left-wing pseudo-liberals who will do nothing to help others, but they'll cry foul when things go wrong with them. They're the worst kind of human beings who can be present on this planet. But anyway, they don't matter. We will always stand for their rights. Uh, the point here was that the protest was slightly on the longer side. Amit Sahni is a case, Tanu. Amit Sahni versus Commissioner of Police, Delhi 2020 case. Amit Sahni was a petitioner. We don't need to know who Amit Sahni is. Like DC Vadwa case, KK Singh case, Amit Sahni case. So, Supreme Court at that point of time remained silent. But later on, once the protest, the people there left themselves because of COVID, then Supreme Court gave a judgment. And here also, Supreme Court has not clarified what is a time frame that you will say beyond this you can't. So Supreme Court has said that we can't fix the time frame. It depends. But this does not mean that you keep on sitting for the indefinite period. So your protest should be for a definite time frame. No definite time frame has been fixed and it will be decided on a case to case basis. Okay, that's there. Anyway, one more thing that is again a common misconception is to strike. So do people have right to strike? Yes, people have right to strike, but you don't have the right to strike as a part of fundamental right. Right to strike is actually a statutory right, meaning a legal right. This, this right comes from a law called Industrial Disputes Act 1947. Not required, but I am still mentioning it. Disputes Act 1947. It's mentioned there. That too, it is not clearly mentioned, it is just defined there. One section 2, subsection Q actually defines what is strike. That is why if you strike, go on a strike, that day's salary is not paid to you. If you are, I mean, if anybody here whose parents are government employees, you ask them, when they go on a strike for pay raise or whatever, say some bank employee goes for a strike for a pay raise, the salary is not given for that day because right to strike is not a fundamental right. Now, these your right to assemble can be curtailed, of course. What is the restriction? Number one, sovereignty of India, integrity of India. Number two, public order. You cannot hamper public order by randomly assembling anywhere. And there are various laws which prevent the uh, any individual from assembling. For example, Indian Police Act 1861. So all those who become IPS officers, you will get to know shortly that whenever somebody wants to assemble or protest in your area, they have to get your permission. Without permission, you cannot assemble anywhere. Those are all called illegal assemblies and they have to be removed by you. Don't use lathi charge please on people. They are our own people in future. But yes, eventually there may be a reason for it, but at the onset, don't. So people take permission from the local police to protest or assemble anywhere. That's a limitation law. Second, there is also a law called Prevention of Seditious Meetings Act. So this is that original law made by Britishers, and all these laws that you have in the country, like MISA. Remember MISA, Emergency Maintenance of Internal Security Act, or National Security Act, TADA. All these dangerous laws, basically, Prevention of Seditious Meetings Act is a precursor. This is been taught by Britishers to us, that to prevent any seditious meetings, arrests can be made. Seditious meeting means what? What is sedition? If you try to plot and plan against the government, and for that you are meeting. Today, say 10 people come and they meet and try to criticize the BJP government. That could come under this actually. Then we know very well section 144, section 141 of CRPC, IPC. These all talk about what? Unlawful assembly. What is unlawful assembly? Unlawful assembly refers to assembly of 5 or more people. So, may not be allowed. Unlawful assembly. Then, how to prevent it? I mean, who gives the order? DM, SDM, or any government officer appointed by the state government can give this order, and the SI, somebody of the rank of sub inspector, not below SI, SI or above, has to impose the order, has the power to impose the order. And if an order is released, then in that area, curfew is there. People cannot assemble. 5 or more people cannot assemble together. So curfew, right? Of that sort. This is there. Then 19(1)(c), right to form associations or unions or cooperative societies. So a small point to be observed here. This word cooperative societies was not there originally, of course. It was added later on. Added via 97th Amendment Act 2011. Cooperative societies. So, restriction on this, the right to form association. Of course, you have a right to form associations, but you cannot form a terrorist association which can hamper public order, which can hamper sovereignty and integrity of India, and of course, which violates morality. That is why we cannot have, what? Any association which is immoral. For example, gambling, casinos, right? Even brothels. So in our country, brothels are not allowed. Prostitution as an organization is not allowed. See, there is no law to prevent an individual from selling sex for money, but it cannot run as a group activity. Okay, because it will then result in formation of an association which violates morality. Okay, that is why you have all these raids on these hotels, the very shady hotels that you have, or these shady spas, or these, what we call the massage parlors, all these things, because the police gets information that some sex racket is going on. It's actually a group activity. So morality is a very important element there, though it's not defined. But that is why individuals are allowed to sell sex for money, but for a group, it is no longer an activity. So for groups, it is not allowed. Okay. Now, to prevent such unlawful associations from being formed, there is a law in the country. One law which is largely being misused. Suhani, please write in Hindi. Suhani, this is an English batch for polity, right? and we have people from all across the country in this batch. So we have to have the courtesy and decency, right, to understand the decorum of the class, make statements accordingly, right? Make statements accordingly, please. So, Unlawful Activities Prevention Act 1967. This is that dangerous law which is being misused largely by the governments across the country, right? And anyway, I'm sure that you have come across this situation that somebody in some state is being arrested under UPA. This is what is UPA, Unlawful Activities Prevention Act. One more thing. This law is applicable on both citizens and foreigners. So it is not that it only covers citizens, covers citizens and foreigners. See, UPA, the origin of UPA was basically a law which you all are aware of. That law was called Anarchical and Revolutionary Crimes Act 1990. Have you heard this law called Anarchical and Revolutionary Crimes Act? If not, I'll tell you a shorter and more popular name for it. Rowlatt Act. The Rowlatt Act of 1919 uh, was basically the original idea, the lineage. So in your history, remember Rowlatt Act? This is actually just a modified version of the same Rowlatt Act. The Rowlatt Act was actually, the full name of the law was Anarchical and Revolutionary Crimes Act. And it was first used in CRPC 1908. And this law has been modified a lot of times. The purpose of this law is prevention of certain unlawful activities of individuals and associations, and also to deal with terrorist activities. So, now mind you, individuals or organizations can be declared terrorists. Even individual can be declared as terrorist. So, this UPA was amended in 2019, and an individual can be declared as a terrorist in the country. Okay. One more thing. If you are a member of an association which has been declared unlawful, that is also an offense. Are we clear on this? Membership of association declared unlawful is also an offense. To give you a simple example, let us say this is a Sakshi, UPA full form. This is a full form of UPA. This is UPA. UAPA. Unlawful Activities Prevention Act. So, simple example. Let's say this is an entire class of say 50 people or 100 people, whatever. In this class, now this is a class to study history, geography, polity, all these things. And let's say you form some WhatsApp group. Okay. Now, after say 4 or 5 years, this WhatsApp group plans and plots and bombs somewhere, and people die. This group is declared unlawful. Members will also be declared to be terrorists by the government. That is what is declared unlawful. Okay. Also, very important, this law has a punishment of 5 years, minimum 5 years to even death sentence. Because if, because of your jurisdiction somebody has died, this law provides for death sentence as well. Now, what is a definition of terrorist act? This law defines terrorists also. So, terrorist act is seen as any act which threatens the unity, any act which threatens or not just threatens or is likely to threaten the unity, the integrity, the security, the sovereignty of India, or strikes terror. So, when we say security, we mean all kinds of security, including economic security of India, or any act which or is likely to strike terror using bomb, explosives, dynamites, inflammables, all such things. Explosive, etc., means using dynamite, using some biological weapons, or even they use a word called any other means of whatever nature. They say some lethal weapon, okay, lethal weapon, any other means of whatever nature. All these are covered. Okay. If you disrupt the essential supplies, that's also covered. And interesting. If you compel the government by kidnapping or hijacking, that's also there. And for you also, if any public functionary dies, that is called a terrorist activity. So tomorrow, don't worry. If let's say you are kidnapped as an IS officer by some organization, the organization will be declared terrorist organization, and if by chance death happens, then that particular organization or the person who has caused death will be given death sentence if they are caught. So you can die by in peace, okay, knowing that they'll be given death sentence. That's today's motivation, right? So it's not a motivation per se, but yeah, the point is that see the elevation of status. If we are kidnapped, it's just kidnapping. If you are kidnapped, it will be called act of terrorism. The elevation in the status by clearing the examination. So that's there. Uh, bank scam. Nidhi, bank scam may not really come under terrorist activity. It depends on the scale of the activity, because if it threatens the security of the country only, so a small bank scam may not really affect the country's security, but it depends on the scale of the scam. So this is the law. Now comes the issue. So there are plenty of issues in the law. Issue number one, what is this definition? Let's look at the definition only. Any act or which is likely to, let's read with me. Any act which is likely to strike terror by any other means of whatever nature. I'll give you an example. Your mother has asked you to fill the fridge with water bottles, and you are delaying and still sitting on the mobile phone. Your mom then takes up the slipper and throws on towards you. It is an act which is likely to cause strike terror and any other means of whatever nature a slipper is being used towards you, which can cause damage also, or is likely to cause damage to property. Is that also a terrorist activity? Now, will you go to court saying, my mom is throwing chappals on me, this is terrorist activity, declare her terrorist? Of course not. So the words are loosely vague, loosely based, very vague. So this can result in misuse, like likely to threaten, okay, or even any other means. So vague words. Second, difficulty in getting bail. Normally, in the words of V.R. Krishna Iyer, bail is the norm, jail is the exception. Okay, bail should be given, but here there is a proper section called section 43D, under which there is subsection 5, where bail is denied if allegation appears to be true. If the allegation appears to be true, bail is denied. Really, this is a draconian situation. Very, very draconian, that bail is normally not given only. And this was changed in 2008. Very difficult to get bail under UPA. Very, very difficult to get a bail. Right? In fact, this entire law has so many sections which are just harassment. Now, it may not be required for the examination, but for example, section 43A, 43B, they give police lot of power to randomly arrest, search and seize property. Section 14 says that all offenses under UPA are cognizable offenses. Cognizable, arrest without warrant. Section 43D, subsection 2, enhances the detention period. You can be detained for long periods of time. Section 43D, subsection 3, it simply undermines the court's power to demand the attendance of an accused. 43D, subsection 4, no anticipatory bail can be sought. Section 43E, same thing, presumption of guilt. You are presumed to be guilty. You have to prove the innocence. In all other laws, the person is deemed to be innocent and the police has to prove the guilt. Here, the onus of proving the innocence is on you. Right? Section 46. If the police intercepts communication done by you, it can be used as evidence. Trust me on this point. Firstly, that as far as intercepting your phone calls, etc., is concerned, firstly, these things cannot be done without the permission. Secondly, these are not used in the court as first evidence, but here they can be used as evidence in the court. This is a very draconian law. And to give you the best possible situation here, as I said, arbitrary powers to state. One very simple arbitrary power is long periods of detention, things like charge sheet filing, 180 days, meaning the police can take 180 days to file a case in the court. Normally, it's only 90 days. Here, the police can keep you in the jail for 180 days, harass you, and then file a case against you. Such is the power. Then it also comes directly in conflict with the state's power, because here neglects State's authority. What is a state's authority? That is police. So when it comes to state, as far as they are concerned, police is a very, very important element. So please understand this point here. This is where you have the NIA versus police issue. The National Investigating Agency has complete right to enter any state and start conducting operations. Then what the hell is the police doing there? This is just like center interfering in the state's power. And not just this, it all boils down to how many arrests are being made and how many people are being proved to be guilty. That is how you assess the quality of any law, right? Let me tell you, very poor conviction rate. When it comes to this law, since 2014 till 2020, we have data till 2020 only, till 2020, there were roughly 10,550. So exact number is 10,552 arrests. Out of which, how many were found guilty by court? 253 were convicted. Convicted meaning found guilty by the court. 253. That is around 2.2%. It is around 2% of conviction rate. Are you joking right now? 98% people you arrest, you can't prove their guilt in court later on. You arrest them, right? And when it comes to providing evidence, none of our evidence stands correct in the court. It is thrown by the court. But the harassment of 6 months, 8 months, 10 months, 1 year, 2 years in jail, who is going to compensate for that? This is the situation. In fact, 40% cases only go on trial. 60% cases don't even go on trial. The police will arrest somebody, keep them in jail for 6 months. After 6 months, they'll leave him saying, sorry, we could not find evidence against you. This is the situation. And of course, the top states include states like, say, Manipur. 30% of the total cases filed are filed in Manipur for UPA. Second is UP, around 20% cases. Then we have Assam, 14% cases. Then we have Bihar, 8% cases. Jharkhand, followed by J&K. Then you have states like Tamil Nadu, etc. So largely misused as a law. I mean, we don't see, basically, the problem with UPA is it has, completely diluted the distinct line between political dissent and criminal activity. A law which was meant for a criminal activity is now being used to suppress political dissent, not by central government, state governments also, not by BJP, every party. It is just that if BJP is there at center, we focus more on center. But look at all these states. It's the states which are harassing and misusing the law, right? So this is a problem. That is why authority given to the government, if it is unregulated, Article 14, rule of law, it is bound to be misused by them. That's all as far as UPA is concerned. Now, coming to the next two categories of articles, 19(1)(d) and 19(1)(e). The articles are different. Their restriction is exactly the same. Let's do one thing. Let's take a quick break. It's just last session. So much of pressure. So we'll take a break. Yes, break. Don't worry. We'll take a break and be back at 7:05. What happens if police dies? Will police help in proving myself innocent? No, Shalu. Why will the police help in proving your innocence? Police has to prove your guilt. Why will they help you in proving innocence? If the police try to prove your innocence, then they have caught you wrongly. If somebody dies in custody, Sakshi, inquiry will take place on what happened. Some internal committee will be formed. And eventually, after a few months, we'll forget all about it. And the committee will give a report that nothing was found, no malafide intentions were there, no problem. The police people will get back into service and they'll enjoy the service. That's it. Shalu, bank looting by terrorists shown in movies. Yes, yes. Terrorists, if they perform any such activity, of course, they are called terrorists for this purpose only. But just a simple bank robbery is not under UPA. It is just a bank robbery is covered under IPC. Simple bank activity is not under UPA. Okay, break please, guys. Yes, Shalu, we can file a case on behalf of others also. Okay. See you guys after the break. Let's continue, guys. Last 50 odd minutes left. So, restrictions on Article 19(1)(d) and 19(1)(e) are exactly the same restrictions. Right to move freely throughout the territory of India and right to reside in any part of the territory of India. They have the same restriction. Sorry, where is it? Oh, okay. They have the same restriction, interest of general public and protecting the interest of any scheduled tribes. Okay. So what are the restrictions? Schedule 5 areas, schedule 6 areas. Then we also have a right to move freely in times of, restricted in times of curfew, not allowed. Apart from that, inner line permit. Then if there is some kind of pandemic, so we have the Epidemic Diseases Act 1897, which can prevent our movement here and there. If you have some kind of contagious disease, Supreme Court, High Court orders. These are all various provisions under which our movement can be restricted, our right to settle anywhere can be restricted. Okay. Nitin, are there some beaches on which Indians are not allowed? If there is some private beach, then quite possible, right? So private beaches may not allow outsiders. That's there. Same thing. Okay. Here also. Same restriction. Same restrictions as before. Okay. Then 19(1)(g), the last of these 6 rights, right to practice any profession or to carry on any occupation, trade or business. So of course you have a right to POTB. Remember in the morning you saw this POTB, profession, occupation, trade, business. So you have a right to practice any profession, carry on any occupation, trade or business. For that, of course, professional or technical qualification is necessary. That's one restriction. You can't say, I love to conduct heart surgeries. I want to now conduct heart surgeries in my house only. Please, come on. Anyone who wants a bypass, come to my house. I'll conduct surgery. Of course, that's not possible. You have to have technical degree, a professional degree. So only then will you be allowed to conduct operations, etc. So for some things, you need to have a professional or a technical qualification. Second, sometimes the government can have monopoly over certain things. For example, you can't say, I have POTB, right to carry any profession, occupation, trade, business. So I will make missiles in my own house. Makes no sense, right? So you cannot make missiles in your own house because government has a right to do it. So government can have monopoly over any kind of trade, any kind of business, any kind of industry, any kind of service. You can't say, I want to start my own police service and hire some 20 friends of yours and you will say, come on now, enforce rules. No, The policing part is given to the government. They are having their own policing powers. Few people practice with qualification like electricians. Uh, okay, but see, I think for smaller things it's okay. We are talking about things which can have a drastic effect on somebody's life. And yes, even for electricians, things can seriously go wrong. That is why we have these ITIs and all, right, where we want all our people to get trained properly and then get to be trained properly and then be allowed to even work as electricians, etc. Excluding citizens, meaning citizens will be excluded. As I said, government can have a monopoly. Government is saying only we will manufacture weapons, nobody else. Citizens, you are excluded. That is excluding citizens. Okay. Are we clear on all these 6 rights? 19, clause 1, subclause A, B, C, D, E, and G. F has been repealed. We are done with Article 19 with all these elements. Moving on, a simple question asked last year, very easy one. Right of movement and residence throughout the territory of India are freely available to the Indian citizens, but these rights are not absolute. Comment. Okay. Simple, right? Article 19, clause 1. Now, herein lies the problem. You need to know which of these two articles are being mentioned here. So, it is Article D, or subclause D and E. And then mention all the restrictions that are there. And you can also give examples. Simple 10 marker question. Okay, great. Now, moving on to Article 20. Article 20 is the protection in respect of conviction for offences. So, what is this Article 20? Article 20 has 3 elements to it. No ex post facto law, no double jeopardy, no self-incrimination. I'll explain all these one by one. First up, no ex post facto law. What this basically means is, whenever you make a law or modify a law providing for some harsh punishment, that particular law will only be applicable from that date. You can't make it applicable from back date. Are we clear? I'll give you a better example to understand. We all know what happened in case of Nirbhaya, December 2012, the Nirbhaya case, right? And we also know that of all the people, one was a juvenile, a minor, under 18. One of them was a minor, right? And we know very well that under 18 kids are not penalized under regular courts. They are sent to juvenile justice homes, etc. And that person was sent to juvenile justice home, and then he was let off after a couple of months. Anyway, but after this particular case, and also hearing the testimony of other people there, the other other convicts claimed that the minor was the one who was the most ferocious in committing that crime, whatever that claim may have been. But that crime was very inhuman. I mean, sometimes some things shock us as to how can a human being uh, commit such a gore act. So, of course, uh, and then no punishment. Why? Just because he was 17 years and some months, not even a jail sentence for the person. So, a committee was formed comprising of or chaired by Justice J.S. Verma. Justice J.S. Verma was the same judge who wrote the Collegium Judgment in 1998. So, Justice J.S. Verma committee was formed, and he gave recommendation that see, uh, kids between 16 to 18 years should be treated as adults if a juvenile justice board looks into the matter and thinks that they are adult or mature enough. So from 2015 onwards, this is the case now that even if you are say under 18 but above 16, you can be treated as an adult subject to juvenile justice board giving the approval. Now, since we have modified the law, can we now go back and punish that juvenile? What do you say? Let's take a poll. What do you feel? Should we go back and now punish the juvenile? A for yes, B for no. Of course, a lot of you are saying no. That is not just because of the law, because it's a very genuine case of misuse by the state. It's possible. If you have this kind of provision that we will enforce, modify laws and start enforcing those laws from back date, then you'll find that the for any such activity, let's say today the government says we are modifying the law, and people who have been robbing or anyone charged of robbery will be killed, death sentence, and this law is applicable from 1950. Call everybody and kill them. This would be highly inequitable, completely unjust. I mean, you are basically punishing somebody for an act that one was free to perform. Understand this point? So we can't go and punish people by applying laws from retrospective effect, ex post facto. Ex post facto from back date. Retrospectively. So, no person shall be convicted of an offence except for violation of a law enforced at the time of the commission of the act, nor be subjected to a penalty greater than that prescribed by the law enforced at the time of the commission of the act. So, whatever punishment is there at the time you committed a crime, or whatever penalty is there at the time you committed the crime, the state cannot impose greater penalty on you or cannot impose a greater punishment on you. Are we clear? So we can modify laws, but those laws will not be applicable from backdate. This is only meant for criminal cases, meaning civil cases it is applicable. If you modify a tax law, it is applicable. So tax laws are applicable from backdate. Criminal cases are not applicable from backdate. Okay. And this is what is the definition of ex post facto law. Not really needed, but you can study it if you want to for a more comprehensive understanding. Second, no double jeopardy. Nitin, criminal justice last season made on this concept. Really? Oh, I did not see the third season. I saw the second season. So not a third one. So I'm not sure what the case story was there. Anyway, okay. If you say so. No double jeopardy. What is double jeopardy? Double jeopardy means double punishment. Punishing somebody for the same offense more than once. For example, let's say in your school days, when you performed very poorly and you got the report card, out of 60 people rank 58 or 50%, 60% marks, you are very sad, unhappy. You go back home, you show the report card to your mom, she thrashes you properly. In the evening, Your father comes, you show him the report card, he thrashes you again. For the same mistake, you are being punished again and again, right? This is wrong. This is not allowed. I mean, your parents can do it. Courts will not do it. Are we clear? No person shall be prosecuted and punished for the same offense more than once. So once you have committed the offense, that's it. Okay, the punishment will be done for that offense only. There is a Latin phrase for it called nemo debet bis vexere. A man must not be put twice in peril for the same offense. It is also mentioned in the US Constitution, Fifth Amendment of the US Constitution. No double jeopardy. See, one point to remember here is, let us say you commit a crime. But when you commit a crime, there are sometimes multiple charges against you. For example, let's say you have committed a crime of kidnapping somebody. Number one, kidnapping, one section. Number two, maybe while kidnapping, you hit the person, assault. Number three, what if the person, for kidnapping, you had to steal some car, robbery, right? What if you threatened somebody, threat also. So all these multiple sections are there, and based on these sections, you can be punished. For each section, punishment separately can be given because you have committed multiple crimes. But once you have committed a crime, let's say you have killed somebody, jail for 14 years. After you come out, we can't say, no, no, sorry, go back again, 14 more years. No, that won't be done. But if you are sent to jail, say for committing a crime, and you come out after, say, 14 years, and you kill somebody else, that's a new crime, a different crime, a separate offense. You can be punished. Okay. Or let's say you plan to commit a crime and then you commit a crime. These are two different things. Planning is conspiracy, separate section. Committing a crime based on crime, separate section. So these are separate offenses. So these things are there. But these are available only in case of judicial proceedings. Courts won't do it. Courts won't punish you twice. See, this concept, I think there was a very old case, USA versus Green case, where 1957, where USA, this case was where the court said that state with all its resources should never be allowed to make repeated attempts to convict an individual for an alleged offense, thereby subjecting the individual to, say, embarrassment, expenses, ordeal, compelling him to live in a continuing state of anxiety and insecurity, right? Because you cannot simply give the police the chance to, punish you, prosecute you again and again for the same crime. Okay, that's it. One more thing. Normally, when this section is told to you, lot of students will make this argument that, sir, but what if somebody is hanged and the rope breaks and the person falls down and does not die? Will we hang the person again? Because the punishment has been fulfilled, executed. Firstly, please understand that what exactly is the kind of punishment that can be meted out to any individual. What kind of punishment? The punishment that is being meted out is hanged by the neck till you die. Okay. So when the rope breaks, the punishment was not executed fully. We'll have to hang you again. Don't be so happy. Basically, these movies, create this confusion. So I think there is a movie called Luck, right? So I had no idea. I mean, who will watch this movie? This Luck was movie starring Sanjay Dutt and Imran Khan, Shruti Hassan, Danny Denzongpa, all these people. I think in that movie, a scene was where Ravi Kishan, this person, this actor, is arrested and is given death sentence. But when he's hanged, the rope breaks when he falls down. And then the background music says that as per Indian legal system, we cannot punish the person for the same offense more than once, and the police had to let him go. No, sorry, that's not the case. It is very clearly mentioned that you will be hanged by the neck till you die, and this is there in the old CRPC also, the new CRPC also. So it has always been the case. Lastly, the third part is no self-incrimination. So when we say, or in the movies, you must have seen the Hollywood movies, right to remain silent. Okay, the accused need not make any statement against his will. When the police arrest them, they say you have a right to remain silent. This is our right to remain silent. Indian police will never say this. They should, but it is our right to remain silent because we cannot be forced into being a witness against ourselves. No self-incrimination. It is the task of the prosecution to establish guilt, not us. We are always presumed to be innocent, right? The task is of the lawyers to establish the guilt and all. Why should I establish my guilt? And you will not be forced into making any kind of statement against your will. No person accused of any offense shall be compelled to. Just a sec, guys. So no person shall be accused of any offense shall be compelled to be a witness against himself. Okay. Of course, this does not extend to things like compulsory production of material objects, giving thumb impression. So the police can collect material evidence against you. They can collect things like blood specimen, specimen signature, exhibition of body, etc. So they can do all these things. So now you may feel that, but sir, we have seen in so many cases the police will ask the person, have you committed crime, etc. They'll slap. That's actually not allowed. Okay. And when the police asks you, you can refuse to tell. And anyway, whatever uh, testimony you give to the police, you can always backtrack on that testimony later on, right? The testimony you give to police is never admissible in the court. It is only admissible if you reveal such information that the police would not have come to know on their own. Okay, if let's say the police asks you very nicely that, sir, did you kill the person, and you say yes, the police cannot use this in the court. It will stand no evidence. But if you say that yes, I killed, and the body has been disposed in that particular place, and the police finds the body, then that statement of yours is correct and it will be taken to court, right? That's there. So that is why these third degree tortures and all these things are not allowed. They are all illegal things. These are wrong activities done by the police. Of course, these only extend to criminal proceedings and not to civil proceedings, as we know very well. Apart from this, one more important thing. So there are some kind of tests that you see, things like narco analysis, right? Or polygraph test. So lie detector is called polygraph, or narco analysis when you are injected with drugs. So basically the idea is that you are given some drugs like say sodium pentothal, etc. See, when you drink, if you don't drink, you don't know. But when people drink, they tend to lose their control over their nervous system. They become more relaxed and they start speaking the truth. The same logic applies. If you are given sufficient drugs, then you may lose control over yourself and you may speak some truth. and that can be used by police to conduct some further investigations. So that is called narco analysis. But please don't try all these things in your house. It is very dangerous. If you try to inject somebody with these kind of drugs, it may result in death also. So these things can be done on the accused, but not without his or her permission. Permission of accused needed for such tests. Okay, without the tests, without the permission of the accused, such things can't be done. Okay, now Article 21. The most important article. Without this article, everything else means nothing, because this is the article which protects life. Protection of life and personal liberty. No person shall be deprived of his life or personal liberty except according to procedure established by law. So, you will not be deprived of your life or liberty except without following a procedure. So, procedure has to be followed. Now, the question is, what is procedure established by law? This is a concept which has come from Japan. To give you a generic idea on what is the criminal justice system like. So, what is the first thing that we do? If you are a policeman, what is the first step in the criminal justice system? Tell me. Please write. What is the very first step in the criminal justice system according to you? FIR. Everybody is saying FIR. Investigation. Somebody is right now. The first step is to prevent a crime. Directly FIR. Investigation. Why so much of anger, guys? Future is looking very bleak. We have to be afraid of people like you who become IPS officers. Complete harassment. See, the first step is preventing crime. Second stage, now a crime has occurred. Then what do? You conduct some preliminary inquiry. Then FIR, further investigation, further some arrests can be made. Then the matter is taken to court, where trial takes place. Okay? Eventually, the court will give a verdict and you will be acquitted. If you are a rich person, you will be acquitted if you are not guilty, and you will be convicted if you are guilty, and then accordingly punishment. Now, the point is that this is the entire procedure which should be followed always. So, let's say you commit a crime, this procedure is always followed. So, your Article 21 can be taken away if we follow this procedure. What is important is to follow this procedure. This has to be followed at all costs. Who follows the procedure? The procedure is followed by executive. Shalu, encounter is not following the procedure. How are encounters justified? ENCOUNT. How are encounters justified? Let's say I have arrested somebody and I was taking him to the court, and the person tries to run away, tries to kill me only. So I try to save myself, and in that the person was killed. That is how every police encounter is justified. Okay? Self defense. Now, who knows what happened at that point of time? So procedure is followed by executive. That is why we say executive cannot take random decisions. We cannot directly arrest somebody and send to jail, punishment. We have to collect evidences, prove the crime, prove the guilt, and then take them to court. In the court also, don't have a lawyer, we'll give you a lawyer. Don't, we gave lawyer to Kasab also. So we take all these steps, right, ensuring that the procedure is strictly followed. That is why procedure established by law prevents arbitrary action by executive, places limitation on the executive. You cannot behave randomly. Fair enough for everyone. Now comes a big issue. Let us say you have followed the procedure properly for some law. But what if the law itself is a problem? What if the law itself is an issue? Let's say there is a law made in the country. If you wear a dress like this, you'll be jailed for 10 years. Jail, 10 years. And then this is a law. New law is made. If you dress up like this, jailed for 10 years. Now we'll follow procedure. We'll tell people, we'll tell everyone, don't commit the crime, don't wear dress like this. If somebody wears, we'll conduct inquiry, FIR, investigation, arrest the person, take them to court, prove the crime, and then get a punishment. Entire procedure is being followed. Yes or no? Followed, right? But the bigger question is, what kind of law is this? I mean, whether this person wants to wear a dress like this or some other dress or no dress, I mean, that's their own concern. Just because I am following the procedure does not mean that the law was right. Are you getting the point? Because I am applying some law, the law should also be right. What if today there is a law which says people who eat chicken tikka will be shot on the spot? What kind of law is this? The law has to be fair. The law has to be moral. The law has to be just. This law here is unfair, it is irrational, and it is arbitrary, unduly harsh. Unduly harsh, completely unjust. Law. That is why we say, who makes the law? Legislature. Every law must be fair, rational, and just. It's very, very important. That is why legislative action cannot be arbitrary. So, due process ensures that we keeps a check on arbitrary legislative action. Clear now? So, just because a law is there does not mean the law is fair. The law has to be reasonable, the law has to be just, the law has to be transparent, fair, rational, etc. These things need to be there. Okay? I hope this point is clear now. This concept of due process was not there in the constitution. This has actually been borrowed from USA. Okay, and that is the reason we find this, that in 1978, in the Menka Gandhi, same Menka Gandhi, her passport was actually impounded by the authorities. Due process was not followed, and when then the Supreme Court said, not only will we check whether procedure is followed, we will also check if due process is followed or not. So originally in the A.K. Gopalan case, Supreme Court had said that we will only check whether the procedures are being followed or not. Because under Article 21, it is only mentioned what? Procedure established by law. But later on in 1978 and onwards, that Supreme Court also says we will also be checking the due process being followed. If it is not followed, meaning if the law is irrational, then we will basically do what? We will cancel the punishment or cancel the arrest or whatever, or we can also cancel the law. I hope this point is clear. So this is with respect to due process of law and procedure established by law. They keep a check on two different things. Procedure established keeps a check on executive action. Due process keeps a check on legislative action. And this is the beauty of Article 21. Article 21 means so many things. Even though you may find that just a few words are mentioned here. No person shall be deprived of his life or liberty except according to procedure established by law. But Article 21 means a lot more than these things. A lot more than these things. In fact, Article 21 is one of the widest articles that are available to us. Widest. Because of the interpretation. Article 21 just does not mean right to live. Supreme Court over the years has said Article 21 means right to live with human dignity. Okay? Right to a decent environment. Right to livelihood. Right to privacy. This was said in 2017, Puttaswamy case. Right to shelter. Right to health. This was in the MS Chawla case, Mohinder Singh Chawla. 1997, right to free education up to 14 years, Unni Krishnan case, right to free legal aid, right against solitary confinement, remember? Shatrughan Chauhan case, 2014, right to speedy trial, right against handcuffing. You can't be randomly handcuffed by the police. The police has to give reasons as to why they've handcuffed you. Right to timely medical treatment, right of prisoners to have necessities of life, right of women to be treated with decency and dignity, right not to be driven out of the state, right to a fair trial, Registrar of Delhi case in 1997, right against public hanging, Lachma Devi case. All these have come to be a part of Article 21. So right to life does not just mean living, it means way more than just living. right against inhuman treatment, right against delayed execution, right to travel abroad. This was the Menka Gandhi case, 1977. Or write the case judgment date, 78. Right against bonded labor, right against custodial harassment, right against or right to emergency medical aid, right to appeal from a judgment of conviction, right to social security, right to economic justice, right to hearing, right to information. Reliance Petrochemicals, case of 1989 versus Indian Express case. Right to reputation, we saw it today only under defamation. Subramaniam Swamy case 2016, right to defamation. Oh, sorry, right to reputation, not right to defamation. Don't defame, please. Then right against bar fetters. These are called bar fetters. This is cross bar fetter. See the cross. Legs tied, hands tied. These are called bar fetters. These are called chain fetters. You have these chains attached. These things are not allowed. You can't chain people. Inhuman. Right to sleep, which you do in the class. I am sure some of you may be sleeping in the afternoon session. So you have fully enjoyed this fundamental right of Article 21, right to sleep. Right? Then right to electricity. Right to marriage. This was in the Hadia case, 2018. Supreme Court has said that you have a right to marry a person of your choice. Of course, the other person should also want to marry you, right? That is there. Don't feel you can marry anyone. They should also want to marry you. Then, right to freedom from noise pollution, right against sexual harassment. Mudrika Singh case. Nikhil, right to sleep. What if family opposed? Marriage, Arjun, marriage, no problem. You can approach the police, get their help. If you are of a marriageable age, you can approach the police and get their help. Right to sleep, Nikhil, basically, nobody can deprive you of your sleep. That is a right to sleep. Article 21. Okay. Solve this very difficult question, came in the year 2021. I'll give you 30 seconds to mark the answer, though 30 seconds is too much of time. Yes, Namita, all these examples can be used in your answers. 69% have marked C, right to privacy. That is correct. I just showed this, that right to privacy is a part of Article 21. Here, how can you mark Article 19? We are discussing Article 20. This clearly shows that some of you are enjoying right to sleep. Article 21. This is the first time that I'm getting such low percentage in this question as a right answer. Solve this question. Let's see if we get more than 90% correct answer here. No, Namita, you don't have to explain these cases. Gulam, right to sleep, also shown in parliament. Sometimes they are old people, they get tired here. What to do? Okay, 86% mark this answer. Some of you, I think, are deliberately marking the wrong answer. B, Article 21. Solve this question. Let's see whether you can get this right. Okay, great. 94% mark this correct. Right to privacy, which was asked again in 2021, is basically Article 21. Simple. That's it. That's it. We are done with Article 21. Let's end our discussion here only. Tomorrow, we'll continue with the remainder articles. We'll discuss the other articles, the rights, then DPSPs, very short topic, duties, then Schedule 8, and we'll be done with our discussion by ending our discussion with preamble and defining the Constitution. Tomorrow is going to be the last class for polity for this batch. Okay, that's all for me, guys. Leaderboard, what to show you leaderboard here? We have just had 2 questions, I believe. Oh, we had 5 questions. Oh, lot of questions. Great. So, leaderboard, Dhaval, Amardeep, Priyanka, Shalu, and Abhinav. Oh, that is why Abhinav was asking for leaderboard. And Priyanka also. Oh, very nice. All 5 correct. 50 points. Then we have next at 4 correct, Nitin, Chanabaswa, Gulam, Jyoti, Sahyadri, Parth, Lekha, Simran, Sudhanshu, Avni, Harjeet, Ravi, Tanu, Pallavi, Nandini, Uday, etc. So you guys got 4 correct. Great. Okay, that's all for me for today, guys. Let's meet tomorrow. Jai Hind. And I'll take some questions that you have. Arjun, it is not a terrorist activity. Can judicial review is based for due process of law? Yes, of course. SIAN, sir, but it's normal dress, so this also can't be wear. What is normal dress? I don't know. That particular thing, that is why I showed the example. Just have to wait for the explanation. Too much of wokeism is happening. Arey bhai, we also know it is okay. That is why the example was given to make you understand the context. Somebody else had mentioned here. What is so wrong in wearing the dress? Nothing is wrong. That is the whole point of explanation. Yes, you can mention cases in answer writing. As far as you can remember, great. It will be amazing. It will improve the answer quality only. Javed, sir, I sent 2 NS. 110 marks, get 3, 115. I won't say it's amazing, but okay. I mean, for a beginner, these are decent marks. Arjun, sir, 1950-51. What is the exact confusion, Arjun? You have to point out some section which you are confused in. 1950 RPA, and the interesting thing is that 1950 RPA or 15 RPA, they are just based for on memory. So you have to mug up those sections. They are just laws, no explanations. Chanabaswa, what about IR class? IR class? IR faculty take IR class. Once these classes are all, you have your next schedule. Don't worry. Schedule is there with you, right? Year-long schedule. Please see that. I don't take IR and all. So IR faculty is there. He'll take the IR classes. Shalu, I took class but not able to revise due to lack of time. How is this possible? Are you a working professional, Shalu? Or are you a college student? The only two conditions where you can't revise are these two conditions. Javed, next class geography. Okay, maybe. College student. Then revise on a daily basis. Are you attending multiple batches? If that's the case, then there's a big problem. So for working professionals, revision could be a challenge. So again, break down your syllabus into small parts and revise on a daily basis, right? And as I said, for working professionals, prefer to study before you go to the office, because once you leave for the office and you come back, you will be exhausted and tired. It is going to be almost impossible to study. So try to plan your studies early in the morning. Say wake up at 3 p.m. a.m. in the morning and that sort. Okay. Then Shali, you are taking multiple batches also, college student also, going to college also. Then what? How will you revise, madam? The whole point of this is to revise multiple times, not taking multiple classes. Revise. You have plenty of time at hand. You are a college student only, right? So what is this hurry to take multiple classes at the same time? Uh, Mathly, not really. You feel it is giving you nice revision, but the point is, it will not reflect in your answer in the examination. Why? Because you have to revise on your own. That's why I say rather than because see, I taught a lot of things today. There would be almost 90% things which you did not even need to recollect, which are very basic. So there you are simply wasting time, right? So revision selectively you can attend some topic in class to see, but attending the entire lectures again and again, I would prefer that you write more answers. That will give you a way better result. Again, it is just my suggestion. Direct about articles. See, don't go crazy about articles. UPSC rarely asks you articles on other areas. But as I said, fundamental rights, please mug up all the articles. Not the article verbatim, the content. If it is untouchability, you should know it's Article 17. If it is a rule of law, you should know it's Article 14. So in that sense, basically, roughly, you should know which article contains what provision under fundamental rights. Beyond that, it is largely the fact that you should know what is mentioned in the constitution and what is not. That would be sufficient. See the PYQs, you'll get to know. Parth, any current issue so that UPSC asks? If UPSC exam is in September, we are covering till what has happened. Current issues can be told to you simply by the current affairs magazine. So in current affairs, if say there's a discussion on governor's point of view, governor's address, read the topic. So that is how you get to know what exactly is more important for current affairs, for the examination. Uh, Anshu, but I write almost everything in the slides, right? All of the articles are come. No, no, no. Remembering articles is not compulsory. Ashwin, what kind of question is this, Ashwin? Of course, without a job. Preparing with a job is a very difficult task. But see, we can't give these random statements, right? Don't leave your job. I don't know your financial situation, right? So, of course, but those who are working, they have their own challenges of financial situation. That's why they're also working and still studying. It's a very, hats off to your effort. But of course, it is way more easy to simply sit at home and study than go to work and then come back and study. So that's it. Chana Baswa, Baiju's monthly magazine, read that, or any monthly magazine of any coaching institute. They are equally good here. Shalu, I think one at a time is sufficient. Meghna, mail me the concern. I'll transfer to the concerned department. Actually, as far as the challenge is concerned, I would prefer that you Read the monthly magazine and read the editorials on your own. That's it. Me on Indian Express. That was a one-time thing because concerned people are not available. It's a very difficult task to manage class and then record the current affairs. Okay, so monthly magazine is better. Who was this? Shreya. Priyanka. Where is the question, Priyanka? And what is the question? So, a chairperson of Commission for SC is required to. No. It is not mandatory actually. SIAN, sir, books did not reach us till now. Really? Mail me this concern. I'll forward it to the concerned team. See, I can't guarantee any resolution. I can just ask the concerned team to look into it. Okay, guys, that's all. Let's end our discussion. Let's meet tomorrow. Till then, that's all for me. Jai Hind.